On August 4th, the Department of Justice published a notice of proposed rulemaking for digital accessibility regulation under Title II of the ADA. So, because it's Title II, this will only affect state and local governments and other public entities. But what's very important is this framework is very likely to be carried over when the DOJ issues digital accessibility regulation for under Title III of the ADA. So that will affect private entities. So this right now we are only in the proposed rulemaking stage. So this isn't a regulation yet. The DOJ is letting the public know of their intent to publish regulation, what the regulation would be, but they're also inviting comment because they want to make sure that they're making an informed decision. And so the basics of this regulation are that it will apply to state and local governments and other public entities, that it will cover websites, mobile apps, and documents. The technical standard will be WCAG 2.1AA, and that larger public entities will have 2 years to comply, and then smaller public entities will have 3 years to comply. So the document for this proposed rulemaking is over 72,000 words, and I did not read it all. But what I've done is I extracted a few questions that I thought were very interesting, and they were also revealing of what the Department of Justice is thinking and the problems that they're encountering as they work to come up with a suitable regulation. So I'm going to read through a few of those. This is by no means exhaustive, but just a few that I noticed. And I'll read the first bunch in sequence because they're all related. What challenges and costs might small public entities face in complying with this rule? Should the department adopt a different WCAG version or conformance level for small entities? How will the proposed compliance date affect small public entities? How should the department define small public entity? So there we can see that the Department of Justice is very much concerned with the ability of smaller public entities to comply with this law. And I've already mentioned that they have longer to comply, but they know that smaller entities have less resources, and so there is concern there, and they want to make sure that the smaller public entities can be in compliance, and there might be levels to this where larger entities have stricter compliance requirements, and then smaller entities don't have as strict of requirements. And then it continues, should the department consider other factors beyond population size? And then another question is, what would the impact of the proposed exceptions on people with disabilities be? So the department is considering various exceptions, but they want to think about the impact that those exceptions would have. Should a public entity be considered in compliance with this part if the entity remediated mobile app accessibility errors within a certain period of time after learning of non-conformance through accessibility testing or feedback? So this is something that we've seen this before, with there being I forget what the term is, but there's a time period where someone can cure the defect, so they can fix the accessibility issue and not face penalty. And then another question is, should the department consider limiting public entities' compliance obligations if non-conformance with a technical standard does not prevent a person with disabilities from accessing services, programs, activities that a public entity offers? So this is very important because it's getting at these accessibility issues that do not prevent access, but they might act as like an inconvenience. And so the Department of Justice is looking at the various, I think right here, the various success criteria that aren't essential for accessibility. They're more of an enhancement or an improvement or an optimization of accessibility rather than something where it has to be in place, or else it could potentially be a barrier to access. Should the department adopt percentages of web or mobile app content that need to be accessible, um, or other similar means of measuring compliance? So I thought that was interesting because here they're looking at, let's say a page is website is 80% conformant. Um, if it meets that threshold of 80%, is it now in compliance with the law? That one's going to be extremely difficult because we could have a website be 95% conformant with WCAG 2.1AA, but if you miss something essential, let's say it's closed captions and you don't have closed captions on your video, even though your website is mostly accessible, it's not accessible for a very key consideration. And then one last question: when assessing compliance, should all instances of nonconformance be treated equally? My answer to that would be absolutely not, because different success criteria have varying impact. But I think these questions are really good questions. It shows the Department of Justice is putting a lot of thought into this. It is a very difficult task. It is extremely difficult to come up with a really an appropriate regulation on digital accessibility, because this is not a yes or no situation. There's a lot of nuance involved, and there's just a lot of thought. And we also have to consider um, the litigation side of this. Would this law invite litigation? Is this law fair to all parties? There's so much that goes into any type of digital accessibility law. But we see this with the Department of Justice's notice of proposed rulemaking. They have put in so much thought here, and now they're inviting comment to really seal the law, make sure that they've optimized it the best they can, and then hopefully this becomes we have a new resulting regulation very soon. But I wanted to touch on this. But again, if you are looking to get ahead of this, you really should already be making your digital assets accessible. But when it comes to websites, you really just make your website WCAG 2.1 AA conformant. Start there, and then you'll be in good shape, and you will be in compliance in advance of the law for the material portion of this regulation. So we already know, and this has been known for quite some time, that it would be WCAG 2.1 AA. It looks like the department is going to provide for some exceptions, or maybe some different tiers, depending on the resources available to different entities. But it's always advisable to go ahead and be ahead of this. And if your website is WCAG 2.1 AA conformant, you're going to be in excellent shape when this regulation does end up going into effect. So that's always recommended. I do have a WCAG course and I have an ADA compliance course. I will link to them below. But I think I really like what the department is doing and all of the thought and consideration that is going into this new regulation.